Hi, this is Shauna with the Tennessee Higher Education Commission. Today you are training us on compliance with Title VI of the Civil Rights Act of 1964. What is Title VI? Title VI of the Civil Rights Act of 1964 reads, "No person in the United States shall, on the grounds of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance." Civil rights are enforceable rights or privileges guaranteed by the U.S. Constitution. Some of those are the 14th Amendment, which guarantees the rights of due process and equal protection, and the 15th Amendment, which provides for the right to vote regardless of race or color. Violation of these and any other fundamental rights may give rise to a cause of action. Discrimination occurs when an individual's civil rights are denied or interfered with because of their membership in a particular group or class, and we'll be identifying those groups or classes covered by Title VI later in the presentation. So what counts as discriminatory practices under Title VI? Denying an individual any program services, financial aid, or benefits, providing a different service, aid, or benefit, or providing them in a manner different than they are provided to others, or segregating or treating individuals separately in any matter related to receiving any program service, aid, or benefit. So this slide discusses the difference between disparate treatment discrimination and disparate impact discrimination. Disparate treatment means discrimination against an individual. Disparate impact means discrimination that occurs as a result of a neutral policy which appears harmless on the surface, but results in a negative impact to a group of people. So on this slide, we have an overview of civil rights in the United States. I'm going to pause for a minute and give you a chance to read over. You'll see that on the last bullet point, in 1964, President Johnson signed the Civil Rights Act of 1964. The Act prohibits discrimination of all kinds based on race, color, or national origin. So those are those protected classes that you're talking about when you're talking about Title VI protection. So when does Title VI apply? The program or agency must be located within the United States. The program or agency must provide a service. The program or agency must receive direct as a recipient or indirect as a subrecipient federal funding or assistance. And federal assistance includes, but is not limited to, block or research grants, student financial aid, training, and use of equipment. What constitutes a program or activity? A department, agency, or other instrumentality of a state or local government, or the entity of such a state or local government which distributes assistance in each department or agency to which assistance is extended. So Tennessee actually has a Title VI law. In 1993, the state of Tennessee became the first state to pass legislation for the enforcement of Title VI compliance in all of its departments, programs, and agencies. The Tennessee Human Rights Commission is an independent state agency charged with preventing and eradicating discrimination based on race, color, religion, national origin, gender, disability, and age. So there you'll see that they deal with discrimination that's covered under Title VI, race, color, and national origin, but they also work on preventing and eradicating other types of discrimination as well. So Tennessee's Title VI law is codified in Tennessee Code Annotated Section 421-904, which reads, "It is a discriminatory practice for any state agency receiving federal funds, making it subject to Title VI of the Civil Rights Act of 1964, or for any person receiving such federal funds from a state agency, to exclude a person from participation in, deny benefits to a person, or to subject a person to discrimination under any program or activity receiving such funds on the basis of race, color, or national origin." So a relevant Tennessee Attorney General opinion is opinion number 9247. The question was, are state agencies, local government entities, private and nonprofit corporations that receive direct or indirect federal assistance subject to Title VI of the Civil Rights Act of 1964 and the Civil Rights Restoration Act of 1987? And that opinion stated that yes, state and local agencies or corporations which receive federal financial assistance are subject to the restrictions of Title VI of the Civil Rights Act of 1964 and the Civil Rights Restoration Act of 1987. It's important to note that subrecipients are also required to comply with Title VI of the Civil Rights Act of 1964 when federal funds are passed from a recipient to a subrecipient. So here are some prohibited practices under Title VI: denying any individual services, opportunities, or other benefits for which that individual is otherwise qualified, providing any service or benefit in a different manner from that which is provided to others in a program because of race, color, or national origin, segregating service recipients solely based on race, color, or national origin, restricting access to program services or benefits because of race, color, or national origin, adopting methods of administration which would limit participation by any group of recipients or subject them to discrimination, addressing an individual in a manner that denotes inferiority because of race, color, or national origin. Also note that Title VI does not apply to employment except when the purpose of the federal assistance is to provide that employment. So how do you comply with Title VI? You need to ensure that service recipients receive equal treatment, equal access, equal rights, and equal opportunities without regard to their race, color, or national origin, and this includes individuals with limited English proficiency. So individuals who are limited English proficient do not speak English as their primary language and have limited ability to read, speak, write, or understand English. These individuals may be entitled to language assistance with respect to a particular type of service, benefit, or encounter. So requirements for LEP to ensure meaningful access to programs and activities, there are 4 factors to be considered. The first is that the number or proportion of LEP persons eligible to be served or likely to be encountered by the program or grantee, the frequency with which LEP individuals come in contact with the program, the nature and importance of the program, activity, or service provided by the program to people's lives, and the resources available to the grantee, recipient, or agency, and costs. So noncompliance with Title VI means failure or refusal to comply with Title VI or other applicable civil rights laws in implementing departmental regulations. Some sanctions that can come from noncompliance are withholding of payments to the recipient under the contract until the recipient is in compliance, and or cancellation, termination, or suspension of a contract in whole or in part. We've included a link to an optional U.S. Department of Justice video related to Title VI. Because this is a video, you probably will not be able to click the link or copy and paste the link into your web browser, so you will need to type that into your browser if you're interested in watching that video. We've also included our Title VI contact at THEC, Scott Sloan. His information is here. If you have any additional questions or need more information, you can contact him at the email address on the screen. Thank you so much for joining us for Title VI training today. Please make sure that you complete the quiz at the following link after completing this training. Again, you will need to type the link into your browser in order to complete that quiz. Thank you again for your participation today.